All right, hello. It is the Disability Law Show. So eager and excited to have you along for the next 30 minutes to learn a lot about disability and disability insurance and dealing with Sivan and his team at the firm. Sivan Tumarkin, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed disability law firm in the land. I'm John Scholes here. You want to reach out? It's simple, 1-855-821-5900. Simple phone number, email help@disabilityrights.ca. And I want to mention the website to shorten that down a bit to simply disabilityrights.ca. Contact information there, lots to learn about disability law and how it pertains to dealing with you and your insurance company. There's also a media tab where you can search our radio shows across the country, 60 minutes long, ton of phone calls, so much to be learned. You can tune into those anytime you would like. But lots on the show today, Sivan. What to know about transitioning from short-term disability to long-term disability. We'll get to that a little later on. We always start off with the week that was, an amusing anecdote, or at least a story on your end, pal. What do you got today?
Well, John, I have a story for you, but it's not amusing at all, and it has to do with COVID. Of course, everything now has to do with COVID, unfortunately. This is to do with a lady, a young woman that called me this week. She's in Vancouver. And she's 32 years old. She's an accountant, makes about $85,000 a year. She suffers from major depressive disorder, exacerbated by COVID and the lockdowns and everything else surrounding that. She has a psychologist that has been treating her for a while. Lots of treatments, lots of things. Now, the insurance company, her LTD insurer, long-term disability insurer, has approved her. She's been on LTD now for just over a year and a half. Okay. And the insurance company recently had her seen by one of their psychologists for an IME, an independent medical assessment examination. And generally speaking, when the insurance company sends you to one of their doctors for an assessment, you can pretty much bet that the opinion of those doctors is going to be favorable to the insurance company, so not favorable to individuals. This is not one of those cases. In this case, the psychologist working for the insurance company actually agreed with the treating psychologist and said, nope, she is still not doing well. Nope. She's not ready to go back. She's making progress, but she's not doing well enough to go back. Well, the 2-year mark is coming up at the beginning of next year. What do you think the adjuster handling her file did, John? Do you think he listened to the treating psychologist and the psychologist that he actually hired for the insurance company to assess her? No, he did not. He cherry-picked information from the insurance psychologist and essentially concluded that she's able to work in some other profession come that 2-year mark. Right. Now, why that's important? Because at the 2-year mark, the test changes.
Change of
the
definition.
eligibility, exactly, the change of definition. No longer is the test, can you do the essential tasks of your own occupation? Now the test is, can you do the essential tasks of any occupation for which you're suited for by training, education, or experience? And really, we're looking at commensurate income. If she's making 85 grand a year, then we're looking, can she do a job at that 2-year mark that pays her about 65% of that pre-disability income? And the reality is that she cannot. But regardless, the adjuster has decided, despite what the insurance psychologist says, that she should be cut off benefits if she doesn't try to go to do some other job. This is a case, when she told me this, and I looked at the documents and the letters, I said to her, look, this is not just a case where I think that we can force them to pay you, to continue paying you, but it's a case where I can potentially get this adjuster in trouble. I can potentially get the insurance company to pay you punitive damages. Why? Because for the insurance company to ignore the opinions of their own doctors that they've hired to assess you, in conjunction with ignoring the opinions of the treating doctors, to me it's a double whammy. It shows that this adjuster, this insurance company, is acting in bad faith. And courts throughout Canada, in various cases, have awarded bad faith damages, punitive damages, to punish insurance companies for this kind of conduct in the past. They continue to do so. Insurance companies are terrified of that. Not because of the amounts. They can swallow the amounts, they can pay the amounts. They're terrified of the precedents that these kinds of cases set in court. Right. And so I think this is one of those cases where, again, people need to understand that even if the insurance doctor says that you can go to work, like even if, not in a case like this, but in a case where the insurance doctor says, I disagree with the treating doctor and I think you are able to work, even in those cases, it's not the end of the, of the road. If the insurance company cuts you off or tells you they're going to end your benefits, you need to reach out to us so we can look at everything for free, by the way, and tell you what your options are.
Okay, first thing, it seems, this may be incorrect, but it seems that when this client of yours, or any client for that matter, starts to creep close to that 2-year mark, and then they say, we want you to go see our doctor, our medical team, it almost seems like the insurance company is starting to circle the wagons for a cutoff. But they're giving you a heads up, so take advantage of it.
Yeah, they're not meaning to give you a heads up. We're giving people a heads up. These are signals. Look, insurance companies are not going to start spending money on their own doctors, on various assessments, unless they're hoping to gain a benefit from those assessments.
Right.
I'm speaking as somebody who used to arrange for these assessments for insurance companies, okay, in my former life, years and years ago. Insurance companies are hoping that the doctors they send you to will justify a decision to end your benefits. And you need to understand that if that happens, that's not the end of the road. As long as you know you're still disabled, as long as you know your doctors are supporting you being off work, you have a case, and the insurance company cannot simply wash their hands off of you. There are options.
Do you, Samfiru Tumarkin, as a firm, can you generally get in the middle of this when you've learned of an upcoming cutoff to bridge the gap, meaning that they won't get cut off, then you have to go through the legal process, then hopefully money starts coming in again. Can you close the gap in time?
That's what we try to do.
Okay.
It depends. Some people, when they're told their benefits are going to get cut off in a month, in 2 months, in 3 months, just wait. They think it's not going to happen. They think they can convince the insurance company not to do it. Right. They think they can appeal it. And what happens is they wait too long. Sometimes, when people come to us, immediately when there is a problem,
that's what I'm talking
we can often rectify the issue and potentially thwart any cutoff. Sometimes we can't, but at least we've primed the environment to ensure that we can get early resolution so you're not without money or not without money for a long period of time. Like, we understand this is a very difficult situation. Most people that come to us, John, have families. They need to feed their families, pay for the roof over their heads. So it's absolutely critical that people, when they have the situation or any questions, they contact us immediately. It doesn't cost a penny to speak to any member of my team. It just does not. So why not do it? Why not get the information? Yeah. Or go to one of our websites and post your question. You'll get the answers. You'll get accurate answers. I mean, to me, not doing that is to just purposefully keep, your head on the ground.
For sure.
And that's not going to help you because the insurance company will take advantage.
Yeah. Phone call anytime, by the way, 1-855-821-5900 and help@disabilityrights.ca. Again, send an email, ask a simple question. I'm going to throw another website at you we use on the companion show, the employment law show with Lior. That is pocketemploymentlawyer.ca. Yes, it is full of employment law information and FAQs and how-to, but there's also a section on disability law as well. Why is that there?
Well, because most people that have issues with their employers also have issues with their long-term disability insurers and vice versa. And we're in a unique position in our offices where we practice in Ontario, Alberta, and BC, where we help people who have issues with both areas of law. Our lawyers focus exclusively on disability law, specifically long-term disability, not workers' compensation, not government programs, but long-term disability or short-term disability and employment law. So if you have a question on either of those issues, disability or employment law, or both, you go to the Pocket Employment Lawyer website, which is free. We've designed this. This was months and months ago, I think, or a year ago or so, a long time ago. And you'll get your answers for free. And they're quick and they're customized. They're tailored to your specific situation. And if you choose afterwards to contact us, you hit a button for a consultation, no problem. If you don't, you close the browser, we will not know that you were there. But the reason why you have that disability section is because most people, when they're contacting us, they have questions on both issues or one of those issues.
Well, I mean, look at your office pre-COVID. I mean, the back and forth between the two offices, you're always on knocking each other's doors because there's so much interplay between the two, right?
Always, always. There's always an issue. Oftentimes people who are on disability, they have issues with their employers. The employers lets them go or says you're not entitled to a bonus or this or that, whatever. The point is people have questions on both sides. And unless you have lawyers or a law firm that had that dual expertise, you could miss something. Your lawyers could miss something because there is that interplay between disability and employment law. They overlap in many ways.
Grab an email quickly. Andrew says, I've been on LTD for the last 6 months following a nasty car accident. I'm in no condition to hold down my regular duties as work, but I'm able to perform small tasks in and around my home with my doctor's permission. My fear is that the insurance company, who warned me that they sometimes do surveillance, will interpret these activities as proof that I'm ready to go back. What are my rights?
Well, your rights are to continue getting benefits so long as you are truthful and so long as you are disabled and your doctors confirm that you're disabled. Yes, insurance companies do conduct surveillance, but look, they can't, first of all, survey you inside your home, number one. Number two, they can't interact with you. The private investigator, whoever they're going to hire, if they hire someone, can't speak with you, touch you, any of that. But the reality is this, you have to go on living your life. And if you, in fact, are telling the truth, remember that in order to get long-term disability, you don't have to be disabled to an extent where you can't get out of bed. You don't have to have a brain injury. You don't have to be catatonic. You don't have to have all the limbs up. You don't. All you have to do is show, with the help of your doctors, that you cannot perform the essential tasks of your own occupation for the first 2 years and any occupation beyond. But it doesn't mean you can't do other stuff. Listen, we have people on long-term disability for years and years who can go and pick up their kids from school. They suffer from psychological type issues, not physical. Conversely, we have people who have physical type issues, severe ones, but nothing psychological, and they heal fairly quickly, or they can do their job, right? You're in a wheelchair, but you can do, still do. So my point is, if the insurance company cuts you off or says, we're going to, well, they're not going to tell you they're going to survey you, but if they tell you we cut you off because of surveillance, you demand to see the surveillance, and you give us a call, and we're going to talk about what you've seen, what the surveillance shows, what your disability is like, again, for free. And in most situations, John, when we have issues with surveillance, the surveillance shows nothing. In fact, in many cases, it actually shows the exact truth. It shows that the person is limited in terms of their capacity and what they can do. So don't be afraid of surveillance if you are being truthful, and if in fact you cannot work. If that's the truth, and if your doctors are supporting you, don't be afraid.
But don't be surprised if the insurance company tries to cherry pick something from it. I mean, this is not free for them to do either, right? They're going to want something out of their surveillance.
It's very, very expensive for them to get surveillance.
Right.
Typically, it costs them a minimum of $1,000 a day. They're not going to put a car outside your house 365, every day for the whole year. They're not. I used to order surveillance when I used to work for insurance companies years and years ago. I'm telling you, most of the time the surveillance is absolute nonsense. It leads absolutely nowhere. That's not to say that insurance company will not try to gaslight you and say, look, we saw surveillance of you going to Tim Hortons, John. Therefore, you are disabled. Meanwhile, you went to Tim Hortons because you went for coffee with a friend, but for the rest of the time that day, you were in bed in pain or something.
Right.
Who knows what the surveillance shows? They will cherry pick. Sometimes they may get lucky and it may look like you're doing something, but you're not. Look, if you're lying, you're saying that you can't do a physical job, but they see you playing a soccer game and they tape you, that's a problem. But most times, surveillance is absolutely useless when it comes to legitimate claims, and we can fight that.
Transferring, or at least transitioning from short-term to long-term disability. We will cover that after the short break. Here's the number as we go, 1-855-821-5900, and email help@disabilityrights.ca. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Alrighty, welcome back. Disability Law Show again. John Scholes here, and with me again this week, Sivan Tumarkin, Samfiru Tumarkin LLP, the most positively reviewed disability law firm in this country. It's pretty good. You want to reach out anytime. 1-855-821-5900. help@disabilityrights.ca. Sivan, let's get into this. What to know about transitioning from short-term disability to long-term disability. Number one, if you are still unable to return to work after going an STD because of an injury or illness, you should be able to apply for LTD.
Yes.
And have a good day. We hope you enjoyed the show.
No. In all seriousness, the test for short-term disability, the criteria, the eligibility, is similar, if not identical, to long-term disability. The problem is that in many instances, the short-term disability and the long-term disability payments are not paid by the same entity. You may have your STD being paid by your employer or another insurance company, or maybe even EI sick benefits, whereas LTD is with another insurer. And people sometimes get stuck. They'll apply for STD, they'll get it, and then they'll apply for LTD and they won't get it. Again, we tell people, look, if the evidence is the same, you're still disabled from working, then you let us know, you contact us. You shouldn't be shocked by it. I'm not shocked by it now. I mean, I think people are shocked because if legitimately they are disabled, they don't understand why the LTD insurer just rejected their application when the STD application was approved. But it does happen. What's more interesting is when you have the same insurance company approving STD and then denying LTD. Mm-hmm. That's really fun for us to actually nitpick as to why that happened. Yeah. You know, do you have two different departments, two different adjusters here looking at two different sets of facts or something? Listen, if you are legitimately disabled, there are no alternative facts. You are disabled and you should be getting LTD. And if you don't, we can help you.
Again, well, that kind of leads to the second point in this, that if you are comfortable with STD or getting your STD, it doesn't mean automatically you will get approved. So how do you guys navigate that? I mean, you said you're going to have some fun if it's the same insurance company, but you're thinking, okay, how do we approach this as a person who's off?
Yeah, I mean, I think it's important to understand that you've been on STD, let's say for 4 months or so. That's typically the amount of time you're going to be on STD. It's important to continue getting treatments, number one, to show that you have continuous treatments. Number two, it's important to get the medical documentation, right? Don't just rely on a letter that was written to you by your doctor at the outset when you first applied for STD. And you give that to the LTD insurer. You make sure the LTD insurer has up-to-date documentation. You make sure that you cross all the T's and dot all the I's in terms of fulfilling the application, applying, making the application itself. And again, remember, insurance companies are in the business of denying claims, not paying claims. That's not how they make their money. They make their money by not paying claims, collecting premiums or not paying. So if you do get denied, you let us know. But typically we say, make sure that the information is current, up to date, and your treatments are ongoing. Don't give the insurance company any reason to say, okay, you were approved for the STD, but we're not going to approve you for LTD because you stopped going to your doctor for treatments or something like that. Just keep doing what you were doing to try and get better. Show it to them, give them up-to-date information, and they should approve you. And if they don't, again, we are here.
And the thing is, much like the employment side where people try to take on their soon-to-be past employer for severance and they get mired in all this paperwork, same thing happens with LTD. People get approved for STD, they get it for a while, then they're denied, they're not approved for LTD. They start going through this whole hamster wheel of trying to fight the insurance company on their own, which they should not be doing. They've got to reach out to you guys to get the compensation because I wouldn't know how to deal with it, right?
John, I 100% agree with you. And sometimes, in fact, last week I spoke to somebody who said to us that the insurance company, when they denied their claim, told them, listen, just appeal the decision. We don't suggest that you go to a lawyer. They cost a lot of money. Like, are you kidding me? I mean, don't go to a lawyer if you don't want to, but certainly don't take the advice of the insurance company here. First of all, we don't charge for any consultations. And if we tell you that we can help you, we'll explain how the process works payments-wise. We work on a contingency, so we only get paid actually if we're able to force the insurance company to pay you something. You're never paying anything out of pocket. But that aside, you have to make sure that, again, you do everything you're supposed to do in order to get compensated by the insurance company. And if they deny your claim, you need to get the information that you need to make a decision on what to do next. Certainly do not appeal those kinds of decisions.
Let's get down a little bit of the minutiae of that situation, though. So if I've decided to try to take a run at this by myself without calling you in the firm, I mean, the average insurance company file on me, if I'm the disabled person, 2 pages, 10 pages, 10,000 pages. I mean, do I even want to bother trying to look into that and figure it out?
Well, first of all, you're assuming you can get a copy of your file.
That's a good point.
In fact, I had somebody this week telling me, the insurance company is refusing to give me a copy of their file. Well, you can't really force them unless you have a legal action against them, in which case they have to provide it to you. So they'll keep their cards close to the chest. Look, I tell people, you can try and take on the insurance company on your own, 100%. You can do that. You can also try and do surgery on yourself, okay? And do dental cleaning for yourself. I would not do that. I would go to somebody who specializes in these areas. I would trust them. It's a question of who to trust. It's a question of finding the right person, and that's all we do, right? We do disability law. We have a specialty in this area. We're known in this area. Insurance companies know that we know this area. They pay our clients. That's one of the reasons why our clients are successful, because we have a reputation. You have to make sure that if, in fact, you do want to take on the insurance company, that you get acquainted with how the laws work, with how the rules of procedure, legal procedure work. You have to understand what the pressure points are with insurance companies. One of the nice things about our team is that we have quite a few lawyers, including myself, that have worked on the insurance side. We've defended insurance companies in the past. That's really nice to have because we know sort of the hidden back doors.
Little Trojan horse.
Yeah, you know exactly what works with insurance companies, you understand their psychology, and you understand where to press in order to get money out. And that helps our clients.
Let's take a short break. We got lots more to go. The phone number, 1-855-821-5900, help at disability rights, and questions and answers, free, anonymous, mydisabilityquestions.com. You can use that anytime you like as well. We'll return. More Disability Law Show is on the way. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, back for a few minutes. Got more to cover, so tuck in. We'll get to it. 1-855-821-5900. The phone number anytime. Help at disabilityrights.ca. And questions about LTD, you can go here. LTDFAQ.ca. All these are free. All of them anonymous, so check them out at your leisure. I mentioned mydisabilityquestions.com. Savannah, I want to get to a question from that website. Nihan writes in, says, after spending nearly 2 years on long-term disability benefits for a generalized anxiety disorder, the insurance company decided to cut off my payments. They said that when my rehabilitation program ends, I will be able to perform the required demands of my regular occupation. Is there anything I can do about this right now?
Yes, absolutely. First question that I would have for Nihan here, John, is what do the doctors say? Are his doctors saying that he can, in fact, go back to work, or are they saying that it's not the right time and he can't? If it's the latter, if they say that he can't, at this point in time, go back to his occupation or any occupation, he mentioned the 2-year mark, then the insurance company is not correct in cutting him off. And they can be forced to either reinstate him or to pay him a lump sum, depending on what happens in the case. But the key thing to understand here is that when you have a generalized anxiety disorder, any psychological type of a disorder or illness, oftentimes that transcends any kind of occupation. It doesn't matter if you're a mechanic or a professor or a dentist or a doctor or a pilot.
It's not a broken leg.
No, it's not. It's not. If you're having issues and it's severe enough that you cannot work, then the question becomes, can you actually do anything else, let alone your own regular occupation? Now, you do have insurance companies and adjusters who are just either stupid, ignorant, or just, I have other colorful words that I can use, and they're just not doing what they're supposed to do, which is to look after the claimant. Right? Insurance companies have a fiduciary duty. Your insurance company, when you make an application under your policy and you get LTD benefits, your insurance company has an obligation to treat you in good faith. That means that the adjuster must take notice, must look at and consider the documentation provided by your doctors. They may disagree for whatever reason, but they can't be blatantly ignoring it. And this is what I would tell Nihan here. I would like to see what the doctors are saying. If he's not ready to go back to work, if his doctors say he's not ready to go back to work, there is no question that we can force the insurance company to pay.
You know, you've said so many times that with mental disabilities, especially when someone's on LTD, it's nuanced. It's not, like you said, it's not a broken shoulder, it's something you put a cast on. So saying this particular person, Nihan, is set according to their doctor, you know what, you can try to go back to work, maybe with some accommodation. That's where the employment side might come in to help in the firm. But what happens if they give it the old college try? It doesn't work. They got to go back on claim. How does that work? And can you guys help in that regard?
Excellent question. Exactly. If you think you're ready to go back, first of all, your doctors need to be very careful what they put on paper. If your doctors truly believe that you are potentially ready to try to go back, they should say that. There's a difference between saying this person is able to go back or is able to try to go back.
Big time. That's
it's a very subtle distinction.
Huge.
And the reason I'm saying is because insurance companies will seize on that. The doctor may say, but that's what I meant. But that's giving insurance companies something to cherry pick if the doctor says the person is ready to go back. Now, let's say the person did go back, as you say, and it's been a miserable failure. A day, 2 days, 3 days, the person is simply unable to go back. They're unable to perform their duties. What can they do about this? Most LTD policies, in fact, every policy I have ever seen, contains a provision or a clause called a recurrence clause. And that means that if within a certain period of time of trying to go back, you're unable to actually go back, in other words, it's been a failure, it's been documented and it's a failure, you should be able to go back on LTD without waiting the elimination period, that period of time at the beginning where you applied and you didn't get paid, 90 days, 120 days, whatever, 180 days, whatever the period of time was. So it's important to understand what that period of time is under your policy. Generally, it's 6 months, but you got to look at your policy. And if at any point during that time you've tried to go back and you've been unsuccessful, you think you need to go back on LTD, make sure your doctors are aware, make sure they provide a report that explains it, make sure your employer is on board if possible, and then tell your adjuster it's not working out. Yeah. Now, in many cases, unfortunately, despite doing everything right, the insurance company will still reject a claim. They will tell you, no, we don't think you tried hard enough. We don't think that your doctor is correct in saying you need to go back on LTD, whatever. Again, at that point, you come to us and we will help you. We'll look at your situation specifically. We'll review the documents. We'll tell you what your options are. But you're right, John. If you do try to go back to work, you got to make sure that you paper it the correct way. Right. You tell the adjuster, that you have certain concerns, but you're going to do your best. You make sure you're in touch with your HR at the company. You make sure you're in touch with the doctors. Because if, in fact, you cannot go back to work, you will need to rely on that recurrence clause to go back on LTD.
Got enough time to slide in an email, which we will do now. Again, help@disabilityrights.ca, by the way. This one, Hannah. My friend was denied long-term disability benefits 1.5 years ago. She's still unwell and extremely stressed and still fighting the insurance company to get her benefits. In fact, she just filed her 3rd appeal. Is there anything I can do to help her?
Oh my God.
Stop the appeals.
One of those things, John, we talk about this all the time. Hannah, first of all, thank you for reaching out. It's one thing I want to say to people. This show is very informative, I hope, but oftentimes when people come to us, it's because a good friend like Hannah or a family member or a colleague reached out to us on their behalf, with their consent, obviously. If you know someone that needs this help, please put them in touch with us or get their consent to get in touch with us. Hannah, your friend is wasting time. It's critical that she gets in touch with us, with me, with a member of my team, because she only has 2 years from the date she was denied her claim for the first time to start a legal claim against the insurance company. Insurance companies love people appealing and reappealing and denying, because at some point when you cross the 2-year mark from the first date of denial, your rights under the law either get extinguished or it becomes extremely difficult to pursue the insurance company. The insurance company literally goes like this or even like this.
Made it.
Yeah. Imagine a situation, I had a gentleman one time that did this by mistake, and he didn't understand, didn't know, and he kept appealing, then he just didn't do anything about it. Long story short, at some point he was beyond the 2-year mark. We explained we can't do anything. That person, by my calculation, was owed close to $800,000. And that money was just simply forfeited because he missed that 2-year limitation period. Yeah. Do not be in that boat. Hannah, please tell your friend to get in touch with us. We'll need to look at everything right now. We will help her.
First of all, don't appeal. We know that now. But is there any difference between appeal number 1 and appeal number 6? Or you're just
no, there's no difference. There is no difference. There's no difference. You need to make sure that you don't play their game. You need to keep power in your hands.
Yeah. Hannah, appreciate that. You know how to reach out through email. I'm going to give you a phone number as we get to the bottom of the show here, 1-855-821-5900. Email help@disabilityrights.ca. And as mentioned earlier in the show, the website for the firm is disabilityrights.ca. There is access there to the media page to listen to our radio shows that have been running for years and years across the country. And then finally, mydisabilityquestions.com. 3 answers and questions, absolutely anonymous. You can use that as well. Appreciate you sticking around. We'll catch you next time on the Disability Law Show.